May I, Lordship?
Yes.
Lordship, I'm seeking an indulgence of this honorable court for allowing me to move an unlisted anticipatory bail, Lordship.
Offense?
Offense is, Lordship, it's 108, it's abatement.
Let it be listed on Monday.
Lordship, I
Since-
have apprehension that
I'll be
might be,
early.
Lordship, I'm not, Lordship, in this case, I'm not connected with the case. In any case, just because I am,
Monday, list. Get it listed on Monday.
Lordship, there's an urgency.
I have to leave early.
Lordship,
It
it
will
won't
be
take much time, not even,
It appears that some orders are also to be passed. It will be difficult.
I understand, Lordship, but since, Lordship, here the petitioner is a woman also, Lordship. Otherwise, if that, and it's a mother of 3 children.
When FIR was lodged?
FIR was lodged on 24 to
24 January.
Yes, Lordship.
No, Monday.
Lordship, I have given my statement also twice before the investigation officer.
No. Monday. Get it listed. It's better.
Lordship, I have apprehension because, Lordship, if I have appeared before the IO twice,
FIR was lodged way back in January only.
not it's February, Lordship.
February 20?
24, 24.
Okay, 24.
And this is today's 27, Lordship. If time permit, Lordship, this may be taken up, Lordship, because I'm a woman and I have 3 children
Well,
also.
just see, because it appears that it's going to take me time. For
Lordship, if time permits, Lordship.
passing this order. If time permits.
Yes,
Let us see, but then not sure.
Yes, Lordship. If
For,
time permits.
Passing order. Okay.
Development.
My Lord, even I'm praying for listing of an anticipatory bail since I'm a teacher, my Lord, and tomorrow I have to attend as a central superintendent. The exams are going on, class 5 and class 8, and I have apprehension that I would be arrested today
Difficult.
because
What is the allegation against you?
allegation is that, my Lord, 108, and then I was nowhere.
In the same case.
Yeah, similar nature of case, but I'm a teacher in this case, my Lord, and I have to attend. I have been appointed as
it
a
appears it will be difficult in the same case.
similar nature of
you-
case, my Lord. Same
You are
FIR.
not connected with.
Same, we are not connected, but same FIR, my Lord. The
Not
allegations.
Not the parents of anybody.
No, I'm not a parent, my Lord. I'm a teacher. I'm a teacher head of that particular school.
The expiry of who expired?
There's a minor student who has committed suicide in the school, my Lord. That is the reason we have been entangled in this case. My Lord, tomorrow I have to attend, and as a monitor, I have to attend a school.
Do we have a court tomorrow? No.
My Lord,
we don't.
tomorrow, that is the reason I'm apprehending I would be arrested today.
No, Monday, both Monday. It will be difficult because it will take time. And for me, if I take up the matter, means would like to pass order, and it will take time. And for me, it will be difficult.
If time
So Monday,
permits, my Lord,
Monday.
may kindly
no, Monday,
try
both Monday,
as the last item because I'm
Both Monday
seriously
only.
apprehending, my Lord.
please. Because I've seen some order are to be passed here in this case.
Seriously apprehending tomorrow. I have been appointed as a central superintendent to monitor the exam, class 5 and class 8.
Let us see.
My
Let
Lord,
us see.
my Lord, kindly.
Not sure.
My Lord.
Don't expect.
May I please your Lordship?
Yes.
Lordship, with the concern from the other side, I beg to mention item number 12. As my senior, Mr. S.K. Medi, has some difficulty. Lordship, if possible, matter may be taken up on 3rd of March.
This is for hearing.
Yes.
Okay. On your for the petitioner,
Yes.
Mr.
KK Medhi.
KK Medi, Lanark Council appearing on behalf of Mr. S.K. Medi, CG, with the consent of the Lanark Council for the respondent, prays for listing this matter
3rd of March.
on 3rd of March. The prayer is allowed. List it accordingly on 3rd March. Okay.
Lordship, interim order passed earlier,
The
maybe
interim order passed earlier shall continue till then.
March of.
May I please, Your Lordship? Lordship,
Uh,
beg to
Lordship.
mention item number
I
item
beg
number
to-
11, Lordship.
Yes, what is it?
Lordship, is a hearing matter, Lordship. I could not travel to Itanagar today. So can it be listed after 3 weeks? I have taken the consent of the PP.
Okay. Mr. You have no objection. Mr.
Lordship, similar matter, Lordship, already been dismissed, Lordship, last week, Lordship.
What is this case about?
This is NDPS lordship. Conviction under NDPS.
Okay. This court dismissed. Okay, on the prayer, on the request made by Mr.
A Bhattacharya lordship. Abhishek Bhattacharya.
Abhishek Bhattacharya, Learned Counsel for the applicant. The matter stand adjourned to be listed after,
3 weeks lordship.
after 3 weeks.
3 weeks lordship.
Okay. Ms.
Hello.
Elhagan, additional PP is also present, huh? Okay.
Like those.
Mayor Lordship, I beg to mention item number 7, Your Honor. Madam, Lordship, senior counsel is out of station here. I have taken consent from the opposite party also.
Is it?
Yes, Your Honor.
This was the order. Huh? Okay.
I on behalf of Jingo here.
Jilolan,
Jingo.
Jingo.
Yes.
Okay. That's. So when do you want, you said after?
Your Honor, if possible, March 27, Your Honor.
Okay. Mr.
Yes, Nabu.
Appearing on behalf of Mr. G. Ingo, Learned Counsel for the petitioner, with the consent of the Learned Counsel appearing on behalf of the respondent, pray for listing this matter on
27 of March.
27 March.
Yes.
The prayer is allowed, listed accordingly on 27
It may be listed in the admission column.
for admission.
March of.
Your Lordship, my please.
Yes.
Your Lordship, I beg to mention item number 10.
Yes.
I appear for respondent number 5. The leading counsel, Mr. Pitafo, is official on leave due to personal difficulties. Kindly list
Have you
this
informed
matter
the
of.
petitioner? Have you informed the counsel for the petitioner?
Yes, Your Lordship. Both
Okay. Mr.
LBM.
Learned Counsel submits that the conducting counsel for the respondent number 5, Mr. P. Tapo, is in this, is unable to appear court due to his some personal difficulties. Therefore, pray for adjournment. He has also obtained
Please kindly
consent
after 2
from
weeks.
the counsel for the petitioner. He prayed for from at least this matter after 2 weeks.
2 weeks.
Okay.
Highly obliged.
Your Lordship, I would like to mention item number 8 and 9 on behalf of the respondent counsel, Mr. S.
Also,
Koyan.
what for it has been listed?
For order, objection hearing, madam.
Objection hearing?
Yes.
Okay, they file objection. Okay. Just.
Your Lordship, leading counsel is out of station.
Okay, Mr. You are Mr.
M. Dolyang.
Dolian, Learned Counsel for the respondent.
Yes, Lordship.
I'm a appellant, madam.
Okay,
Bajaj Alliance Company.
you have objection?
No, no.
No, okay.
Objection, they have.
Con-
raised an objection.
Counsel for the respondent, prays for adjournment of the, why you are praying adjournment?
Your Lordship, leading counsel is out of station.
Okay, submits that the leading counsel is out of session, therefore pray for adjournment, to which Mr. Udeka, Learned Counsel for the applicant, has no objection. They are allowed, list this matter after
1 week, Your Lordship.
a week. Okay.
Item number 1.
Your Lordship, this matter should be on VC. This matter may be on VC, but due to some technical error, my leading counsel of this matter could not join on VC. So kindly, Your Honor, the matter may be listed on Monday, 2nd March.
Lordship,
This petition is not
yes,
maintainable.
Lordship, not maintainable, Lordship. Because both these sections are compoundable offense.
You approach the trial court. Okay, will dismiss it with liberty to approach the trial court. It's compoundable only. Okay,
Yes, yes, Lordship.
hard, Mr.
Elbing
Learned counsel for the petitioner. Also heard Mr. El Hadi, learned counsel. Allow me additional PP for the state. Start. Sir. This application under section 528, and this petition under section 528 of the BNSS 2023 has been filed jointly by the accused and the informant in 0PS, the informant seeking quashing of the 0PS case number 03/2025 under section 3182 stroke 3162 of this 2023. And the input order dated 10/3/2025, whereby NBWA was issued against the petitioner number 1. Prejudice order dated 17/12/2025, whereby the proclamation was issued against the petitioner number 1. Farah. It is submitted that the offense were registered against the accused petitioner number 1 are all compoundable. And compoundable stuff, para. The learned edition PP. Some status. Since the matter is compoundable, the petitioner has a alternate remedy to approach the trial court for compounding of the case. Stava para. Since the offense registered against the accused petitioner number 1 is compoundable in nature, the petitioner and the informant has no objection come. The petitioner has alternate remedy to approach before the trial court for compounding of the offense in accordance with the provision of BNSS. So in petition, item 3, this is against whom?
Item number 3.
Hmm.
Item number, okay, 2, and now this is 3. And this is against the uncle of the wife. Since the uncle was the mediator, that one name, this petitioner name is
Okay, and then what about this item 4? 4 is by,
by a mother-in-law, has lodged an FIR against the son-in-law,
against?
against the son-in-law, the husband.
What did son-in-law do?
Actually, they were
For what? This is item 4 is for what?
Item 4 is for, that's also for quashing.
No, no. Just a minute. This item 4, laws by the husband, father-in-law.
No,
against
mother-in-law.
Against son-in-law.
Yes, mother-in-law against son-in-law.
Mother-in-law.
Yes, mother-in-law.
No, this Hilang Takang is not a son-in-law.
Hilang Takang is a son-in-law.
He is son-in-law.
Yes, he is a son-in-law.
No, no, no. So Hilang Takang in item number 2, he is a husband. How
Yes.
he becomes son-in-law?
Lordship, in item number 2, one criminal petition number
Okay, let us
141.
take up then separately,
Yes,
one by one.
yes. Here, this is the dispute in
Yes, just a minute. Have you received
Lordship,
any instruction?
yes, Lordship. Since
Okay.
IO is out of instruction, so just report it.
Okay, what is the report?
Nothing there, Lordship.
I think there.
Yes, Lordship.
and I have a receipt copy of that PS, all the 3 PS.
You have filed
Yes.
application for withdrawal of the FIR also?
They are not allowing for withdrawal because it's
No, no,
already
have you
registered.
submitted?
Yes,
otherwise?
it's submitted.
Do you have the copy?
Yes, I have the copy.
Just share a copy to the PP also. PP, you have any information that they have otherwise tried to submit for withdrawal? Have they submit?
Lordship, no. In the status report, yes, nothing, Lordship, nothing.
Or it's there?
No, Lordship. Only stated that
This is going on.
in investigation the offending due to the
This is one.
since IO is out of station for executing, Lordship, some NBWs in the other state, Lordship.
Okay.
Since Lordship, in Lakshmi Narayan as well as in Gyan Singh case, there's a cat and dog cases where if there's a
It's talk about the FIR also.
yes, yes,
Question
Yes.
of FIR also.
Yes,
While-
Lord.
While the matter is still under investigation.
yes, yes, Lord.
Can you just once?
In Gyan Singh, it's para 61, and in Lakshmi Narayan, it's a paragraph 15.
Hmm?
And similar case has been caused by this honorable court also in some cases also. So in this operated part, this honorable court only, where means all those cases were discussed by this honorable court only, this bench only.
Is it this court?
Yes, by this court only. Itanagar bench only.
Have you appeared before the police? In, you
Yes,
have been issued notice. Have you appeared?
Lordship, it's a case, it has been registered in the month of this February only. When registered in the month of February 12th, and it's been only the filing of this quashing petition, it's been 12 or 13 days only. So during that period only, meanwhile, they settle within themselves.
As per the as per the status report, Lordship, accused statement was not recorded, Lordship, not yet recorded, Lordship. Only victim statement was recorded, Lordship.
So they are aware when the matter has been settled, amicably settled, and they have also intimated the IO,
Yes,
the officer in charge,
yes,
that they would like to withdraw the FIR. This intimation was given.
yes.
So you have objections?
No, no, Lordship.
Hmm?
No, no.
Okay.
If I was informed that the petitioner,
Yes, they are outside
within
only.
the outside
With-
premises. of the
The
court.
informant and the accused.
Yes, they are also within the premises because previous occasion, last day, because instruction from this honorable court is that they should approach the IO of the case.
Hmm.
So initially, those IO, they were reluctant to give this receipt copy.
You want to confirm the
They are here only,
call?
right? If required, that's why I informed the PP also. If
Otherwise, the Lordship, I have no objection.
No objection.
then
Okay.
yes,
So let us just see once confirm
Yes,
if they are the informant
yes,
and the victim.
yes,
And if they says that they have compromised or mutually settled,
yes,
we'll pass necessary order.
yes, Lordship.
You have no objections,
No.
we'll record that.
even Lordship, it's this settlement has been also executed properly.
Okay.
It had been executed, properly executed.
Properly executed means where?
Before the notary public.
Hmm.
So it's a genuine settlement, Lordship, and there because allegation is also very interesting. That wife allegation is that my husband is again with the relationship with my divorcee first wife.
Hmm.
So that's the reason I left this home. And that's the reason I took all my belongings. So that's in the FIR. on record.
Including the belonging of husband.
Yes.
That is why.
Yes. So now they wanted to conduct the Anyada, to solemnize their marriage as per the Nisi customary laws and practice.
Okay, heard Mr. P. Gipa, Land Counsel for the petitioner. Also heard Mr. Lawyer. Land PP for the state respondent. So, Pan. This petition under section 528 of the BNSS 2023 has been jointly filed by the petitioners and the accused and the victim seeking quashing of the Itanagar Women PH case number 12/2022-26 registered under section 85 of BNS 2023. No, Itanagar Women PH case number 12/2026 dated 12/2/2026 registered under section 85 of BNS 2023. As well as the proceeding. In GR number 124/2026. Pending before the judicial magistrate and the chief judicial magistrate before the Land Court of Chief Judicial Magistrate, Capital Complex, UPA, and Itanagar. Stop. Para. The petition, the petition number 1 is the husband, and the petitioner number 2 is the wife. And the petitioner number 1 is the husband who lodged a fire against his wife, petitioner number 2. Alleging that on April 2, 2026. It's 12/2. No, 29. 29/1, 2026.
Yes.
Okay.
FIR was lodged on 29, but it was registered on 12 of 02.
How it is? The FIR is at 15, page 15. This may not be the one.
Yes, Lordship,
No, this may not be the one.
15, page number 15. Type copy is in page number 18.
Here, then husband is the accused here.
Yes, Lordship.
Okay, then change it. Na? Petitioner number 1 is the, and then the 2 is the wife who lodged an FIR against her husband, petitioner number 1, alleging that on 28/1/2026, okay, this was registered on 12. Why it was registered only on 12?
I'm not aware about why it was registered, because the incident happened on 28th.
Okay. Alleging they are in that, alleging they are in that. She was in a marital relationship with the petitioner number 1 since 2021. However, the petitioner number 1, who claimed to have divorced his earlier wife, concealed the pendency of divorce case with his first wife. And continue to maintain illicit relationship with his ex-wife, which led to repeated dispute and assault upon her. Subs- Accordingly, a case was registered. According to the aforementioned, woman PS case was registered. Stop. Paragraph. The land counsel for the petitioner submits that immediately after registration of the case, the parties being wife and husband had amicably resolved the matter and resolved their dispute and settled the dispute by executing a deed of settlement, a mutual deed of mutual settlement on 19/2/2026, whereby it is stated that due to misunderstanding between the wife and husband, the petitioner number 2 lodged the instant FIR against the petitioner number 2. Sorry, 1. However, and since the matter has amicably been settled with the intervention of the elders and relatives, the informant has no further grievance against the accused applicant number 2. So, petitioner number 1, and she does not want to wish to pursue with the matter any further, and therefore she also intimated the officer in charge, expressing officer in charge stating that she wished to withdraw the FIR lodged by her against the accused petitioner number 1. Stop. Para. The land counsel for the petitioner further submits that since the matter has amicably been settled between the parties, and she has no further grievance against the accused, the further proceeding of investigation of the case would only futile exercise and would cause harassment to both the informant as well as both the accused husband as well as the informant wife, and therefore prays for quashing of the further proceeding of the aforesaid women PS case number so and so. Stop. Clara. Mr. Lauren, Planet BP on instruction. And then just a minute. Sami said he has received a status report. Of the of the aforesaid women PS case. The matter is still under investigation. However, since investigation, and however, since the matter has already been resolved between the informant and the accused, being wife and husband, and the allegation in the FIR itself indicates that the matter arises out of the marital dispute. In view of the aforesaid, in view of the settlement between the parties, has no objection if the prayer of the petitioner is allowed. He further submits that he has also received a copy whereby the informant addressed to the officer in charge of the police has expressed her willingness to withdraw the FIR lodged by her against her husband, petitioner number 1. Under the circumstances, he also submits the Lanet BP also fairly submits that the further proceeding of the case would not help the project, would only cause harassment to the parties. And it will amount to a abusive process. I have heard both the Lana Council for the parties and also Perusta status report. It appears that the dispute arises between the wife and husband when the accused husband alleged to have involved in, alleged to have continued to maintain his illicit relationship with his ex-wife, whom ex-wife, due to which, because of which there has been a dispute between the wife and husband, resulting lodging of the aforesaid women PS case against the accused husband. Not there. However, subsequently, it appears that the matter has amicably been resolved and settled by executing a settlement deed between the informant and the accused husband, whereby the wife, the informant clearly expressed that the aforesaid FIR registered under section, being so, FIR being so and so, registered under section so and so, has been lost due to misunderstanding between the wife and husband. And now she has no further grievances against the accused petitioner number 1 and does not want to pursue any further stuff. Under the circumstances, it appears that the dispute is purely a personal and an arising out of the marital discord. When we, under such circumstances, there is hardly scope of any conviction against the accused. And thus, if the investigation or the trial is allowed to be continued, it will amount to, it will only cause harassment to both the parties, which would only, which would amount to an abuse of the process. That in view of the above, abuse of the process and stuff, then I'll conclude it. Okay, I'll bring out this Gyan Singh and then
Lakshmi Narayan.
okay.
Yes.
Yes, Gyan Singh and the
If Lordship is required, I have a note,
two
quick note
cases.
of remaining
Two
cases also.
What note?
That's a relevant paragraph. Or it's okay.
It's fine only.
Okay.
That will be brought, will bring up, okay? These and the other cases, Gyan Singh also, yes, Madan Lal. Paraha. In view of the last, in view of the above, the petition is allowed. Accordingly, the proceeding of the investigation in Itanagar 1 PS case number 12, 2026, registered under section 85 of BNS 2023. The PS case dated 12/2/2023, registered under section 85 of BNS. And proceeding under GR number 124/2026 before the Learned Court of Chief Judicial Magistrate against the accused Ilang Takang thereby passed. Okay, with the above, this petition stands allowed and disposed of. One and the other one.
Here in this next
So
one,
who are otherwise the
same,
things, these all arose out of this same
yes,
case only.
yes.
Okay, then fact would be little different. Okay, in the then hard same, in item 3 would be. Here also the Husband is low.
No, here, actually uncle. Husband and uncle.
Okay.
Takang is a husband,
Hmm.
and Takang has lodged FIR against the uncle for taking out all this belongings from his resident. Since this uncle was a mediator only to resolve the case.
Okay. We have annex FIR here.
Yes, Lordship. FIR is there in page number, here also page number 15 to 16.
Here section is
Section is 305. Tap. Page number,
hard scam, huh? And then here for Quashing, the number of the the case number would be Bandadeva PS case number 10/2026 under section 305A stroke 3 within bracket 5. What is this 305?
305 is tapped. Tapped from dwelling
Okay.
house.
Okay. 3/5 of BNS. FIR dated as 16/2/2026, huh? And GR case would be 140/2026, huh? Then the petitioner number, then it will be petitioner number 1. Who is the informant? He is the, okay, he is the informant, huh? Informant within bracket victim. The petitioner number 2 is the uncle.
Yes, maternal uncle of the wife of Hilang Takang.
Okay, the maternal uncle of
Petitioner's wife's Srimati Tana Apu.
petitioner's wife. Star, huh? Sarah. Okay, the brief fact of the case leading to the filing of this petition is that the petitioner number 1 lodged a written FIR before the IO, so officer in charge, police station, Bandardeva, inter alia alleging therein that on 28/1/2026, when he came back home, he found his door open and all articles been taken away by some unknown person. Stop on inquiry through CCTV footage. On checking the CCTV footage, he came to know that the accused petitioner number 2, along with 4 others, entered his rented house, broke open the door, and stolen away all the belongings and household valuable items, including ornaments, document, and case amount. mobile handset, etc. Then case amount, furniture, kitchen items, and mobile handset, etc. He said that even single glass was not left.
Yes, wife was there.
So according a case was registered. The aforementioned case was registered under section 12. So okay. Para. The land council for the petitioner submits that this case is arising out of it was arising out of the dispute between the petitioner number 1 and his wife. Stop. In the process of conducting marriage stroke within the Nyada, a dispute arose between the husband and wife, where out of fit of anger, husband told the wife if she doesn't want to live with him, she can leave.
Yes.
Accordingly, the wife took away her belonging from the rented house where the present accused petitioner number 2, who is her uncle and the mediators between the petitioner number 1 and his wife also participated. However, the affair has been lost in the uncle leaving the wife. Wife was also accused here.
No.
Okay. Stop. The non-counsel for the petition further submits that since the dispute arises between the wife and husband, with the intervention of the relatives from both sides, the matter has been resolved. The matter has been amicably resolved between the parties, and executed a mutual settlement deed on 19/2/2026, whereby the informant has expressed and stated that the aforesaid FIR was lodged due to misunderstanding between him and his wife, where the present accused participated. In support of his wife. However, since the matter has amicably been resolved, he has no further grievance against the present accused and does not want to pursue with the matter any further. Therefore, subsequently, he has intimated the IO of the case, expressing his desire to withdraw the FIR lodged against the accused. Stop. However, since the offence alleged against the accused is it also non-compoundable?
Yes, Lord.
Okay, non-compoundable. The matter could not be compounded before the police station. Stop. In view of the above, the Land Council for the petition submits that since the matter has already been resolved amicably between the parties, there is no scope of any conviction in the case, and therefore further proceeding of the case before the further proceeding of the investigation or trial against the accused would be a futile effort, and therefore the futile effort and a view of the process. Therefore, he prays for question of the FIR as well as the proceeding there to start. Para. Same, Mr. Then Mr. Goeha, Lara PP. Clearly submits that in view of the subsequent, in view of the mutual settlement between the parties, and considering that the matter arose due to the dispute, dispute and misunderstanding between the wife and husband, and that the uncle only accompanied the wife in taking her belongings from her rented house, and also considering that the informant expressed his willingness to withdraw his FIR, there is and that there is a bleak chance for his conviction, he has no objection if the petition of the petition, if the present petition is allowed. Stop. Per hardboard planet. Same. Okay. And then
This
next would be
this one is informant is mother-in-law, and accused is that Ilang Takang only, the husband of that.
Here accused is okay. Then mother-in-law, why?
Lodge FIR against
What is the allegation?
Allegation is that there is a criminal trespass and mischievous destruction of some property, and criminal intimidation is there. So that's a Sagali PS.
Oh, this is Sagali.
Yes. So since
Their own place, they have lodged FIR.
yeah, actually the husband,
And everyone. Okay.
yes, after the incident went to visited his mother-in-law resident to find out his wife.
Okay.
So that's the main case here. Otherwise, there is no case.
So while visiting mother-in-law, presuming that she will no longer be wife, so he threatened
No,
mother-in-law also.
no. Here actually the wife was kept at the residence of the uncle, but husband was not aware about that. He
Okay.
thought she might be there her
In the-
on parent residence.
Okay, parental house.
So that's the reason he went there.
Okay. Same hard, huh? Then the petitioner number clarify the party. The petitioner number,
One is Takang, only husband.
Hmm?
One is husband and two is petition number two is mother-in-law.
the petitioner number 2, and the one is the accused. And the petitioner number 2 is the informant, mother-in-law of the petitioner number 1, who married to her daughter. Stop, huh? Okay, para. It is submitted, huh? Okay, then the brief fact again, huh? The brief fact of the case leading to the filing of this petition is that due to the misunderstanding and the dispute between the wife and husband, within bracket the petition number 1, huh? So earlier FIR was lost. Okay. Okay. The wife of the petitioner number 1 left the house, taking away all the belongings from the rented house. Leading to filing of FIR against his wife. Semicolon. And in search of his wife, the accused petitioner visited his mother-in-law at Sagale and there was some altercation between the petitioner number, between the mother-in-law, petitioner number 1, and the accused, who is the son-in-law of the petitioner number 2. Stop. Since the family was under dispute during the performance of Nida of the children of the petitioner number, the accused petitioner number 1, and his wife, the present informant, out of fear of anger, has lost the present Sagale PS case number. Lost FIR against her son-in-law, leading to registration of the Sagale PS case number 11/2026 under section 324, 1, 329, 351 of BNS 2023. Stop. Huh? Then para. Huh? The learned counsel for the petitioner submitted. However, during the pendency of the investigation, as the dispute arises between the wife and husband, the entire family, the matter has been amicably settled with the involvement of the elders and the relatives of the accused petitioner, number one, and the informant. Mother-in-law, who acted in support of her daughter, who is the wife of the accused petitioner number one. Stop. Para. Not para, huh? It is further submitted that in the settlement deed, the informant has clearly expressed and stated that the FIR was lodged against the accused petitioner number one due to misunderstanding arose between her daughter and the accused petitioner number one husband. Accused husband petitioner number one. And since the matter has amicably been settled, she has no further grievance against the accused and does not want to pursue the matter any further. She further undertakes to cooperate with the accused petitioner for withdrawal of the for quashing of the FIR. Accordingly, she also intimated the IO of the case, expressing her willingness to withdraw the FIR lodged against the accused petitioner number one. Stop. However, since the offense registered against the accused petitioner number one is non-compoundable offense, therefore,
Only 351 is a non-compoundable offense.
Hmm?
351 is.
okay, hence this petition for quashing of the aforesaid woman PS case, not woman PS case, and Sagali PS case. Have you also mentioned Sagali PS case number in the agreement?
Yes, yes.
Where do I
It's
find?
35, page number 35. Condition is there in page number 36
Okay.
and para 3.
Okay. Okay, Sagali PS case number 11/2026. Stop. There. The Learning Council for the petitioner further submits that since the matter has amicably been settled between the disputed parties, there is no scope of any conviction of the accused in the case, and under the circumstances, if the investigation stroke trial is continued to proceed with against the accused, it would amount to causing unnecessary harassment and to the parties, and which would amount to a abuse of the process. Stop. Process of law. Stop. Therefore, we praise for quashing of the aforesaid FIR, aforesaid Sagali case number. This is also pending. This also has been registered.
Under investigation.
Does it have a GR case number?
Yes, Lordship. It's GR case number 107 of 2026.
Okay. And corresponding GR case number 107 of 2026.
26.
Stop. Okay. Then again, same Mr. EP, huh? Okay. Then hard. The same conclusion will be same. Okay. Any other? That's all. That's all.
That's all.
Only 3 cases.
Yes, Lordship.
Okay.
Good.
highly obliged.
Item number 5.
Lordship,
Wait, please, Your Lordship. Your Lordship, this is a joint petition filed for seeking quashing of FIR number 01 of 2026, registered at Lika Bali Police Station under section 239 subclause 4, 118 subclause 1, 305 subclause A, section 74, 351 subclause 2, and 3 subclause 5. Your Lordship, the petitioner number 1 is the accused person and petitioner number 2 is the informant herself. And the said incident arose due to some personal misunderstanding between the family members. And Your Honor, both the parties have settled the matter through and executed an agreement dated 16/2/2026, which has been, Your Honor, annexed as annexure number 3 in page number 32 to 34, Your Lordship. And Your Lordship, both the parties,
Just a minute.
this
What is the allegation?
allegation is,
Attempt to murder.
no, Your Honor, it's 329 subclause 4 is house trespass.
3.
329 subclause 4.
Okay, house trespass.
Ye-
And then
yes.
118.
And voluntary causing grievous hurt. And 305 is theft. And section 74 is assault or use of criminal force to women with intent to outrage her modesty. And section 351 subclause 2 is criminal intimidation and common intention, Your Lordship.
Lordship, connected AB is pending, Lordship, which was fixed on, Lordship, was fixed on 2nd of the March, Lordship.
Smart.
So this may be taken together, Lordship. Lordship,
Matter?
Lordship has retained the CDs, Lordship.
Oh, series there.
Yes, Lordship.
When it is fixed?
AB 07 of 26
When it is fixed?
on 2nd of the March.
2nd March, Monday.
Yes, Monday. On Monday.
Okay, then Monday along with the CD
Yes.
and an updated CD if
No
it is
updated,
for-
Lordship. Lordship has retained the CD.
Okay. Is original or a scan copy? Probably scan copy,
Lordship,
because now they have come with the new, that is along with the agreement.
yes.
Now probably he is entitled for the anticipatory bail
Yes, Lordship.
because he doesn't have, the informant doesn't have any further grievances.
Yes, it
Yes, it appears. Okay. Then hardness,
Why Singhi?
Lana counsel for the petitioner. This petition under section 5 to 8 of the BNS has been filed jointly by the accused. Petitioner number, who is the accused?
Accused is petitioner
one is
number
it?
1, Your Honor.
Petitioner number 1 and the informant petitioner number 2 seeking quashing of recovery. Yes, case number 0126. Registered under section 329(4), 118 within the 118(1), 305A, 74, 351(2), 35 of BNS 2023. Which one is non-compoundable?
Your Honor,
Okay.
only section 329 subclause 4 is compoundable.
Okay,
Others-
notice. Since Mr. Lloyd, who is present, accept notice on behalf of the state respondent. No formal notice may be issued. Mr. Lloyd further submits that Mr. Lloyd and PP further submits that the AB
07, Lordship. 07 of 20.
the anticipated bill being 07/26,
Yes, Lordship.
taking bail applications taking anticipated bail in connection with the Kabali PS case number 01/2026 is pending before this court, which is fixed on Monday. Record has also been called for and retained by the court or by the
By the court, Lordship.
council.
By the court, Lordship.
Okay. Therefore, this matter, therefore he prays that this matter may be listed along with the AB
Yes.
number
07,
07/2025 on Monday. Okay.
2026, Lordship.
Okay. Listed accordingly on Monday. Okay.
Tably observed.
Along with the AB. Huh?
Tably
Okay.
observed.
Item number 6,
In the meantime, you obtain updated CD because that is for AB only. Okay. On which state the line PP shall produce the updated case CD, huh? Scan copy of the updated CD. Okay. Item 6. Yes.
Lordship, before going through, I would like to apprise this Lordship may see the page number 34 of my petition. It's a arrest memo. Page number 34. And Lordship may see the additional affidavit, page number 68.
Arrest memo is
Page number 34 in this my main petition, and in additional affidavit, that's page number 68. Both are the arrest memo in different case. On previous occasion, categorically, I had not specifically cited that he has been alleged in another case. So that's the reason this additional affidavit has been filed. But it was not concealed because in this Nirujli PS 82 that was shown arrested, in that case, I had been granted bail. So here my submission is that, Lordship, I had been in judicial custody for last 169 days.
Okay.
And my remaining alleged accused friend, they had been enlarged on bail. And charge sheet has also been filed, and it's been 68 days now after filing of the charge sheet. Now, here actually, I'm here before this Lordship is that I had not been furnished the ground of arrest. So based on that, my plea is one plea is that, and that's on record, means arrest memo is on record. And second thing is that I would like to apprise this Lordship that as per this means allegation over here in section 13 of this UAPA Act, that doesn't fall under the restriction and prohibition for bail. So that doesn't fall, it has been decided in Somakanta case also. And apart from that, Lordship, I have
What did you say there? The UAP? that
UAP.
before?
UAP, there is a provision that if suppose some section from chapter 3 onwards, if that section reflect, then if that section fall under as like a NDPS, section 37, notwithstanding clause like that, then only there is a issue regarding the bail. But here, either my means allegation doesn't fall under that. So technically, Lordship, I'm here.
It's not 180 days.
No, not regarding, yes,
Okay.
not yet. So here, Lordship, technically, actually, I have not been granted, given, furnished the ground of arrest. That's one. Second is that as per the one, I would like to apprise this to judgment in Vihan Kumar, paragraph 16. One Vihan Kumar, that paragraph 16, which I mark.
Yes.
Yes, if the ground of arrest is not furnished, then
Paragraph?
paragraph 16, para 16. There are two cases. One is Vihan Kumar, one is Sanjay Chandra. In Vihan Kumar, Lordship, in paragraph 16, may I read, Lordship? Even though charge sheet is filed.
Para 16.
Yes, Lordship. So may I read, Lordship?
Yes.
This court held that the language used in,
No, where? This is Sanjay Chandra,
not Sanjay Chandra, Vihan Kumar.
Vihan Kumar.
Yes, Vihan Kumar.
Yes.
Paragraph 16, Lordship. This court held that the language used in Article 22, Clause 1 and 22, Clause 5 regarding communication of the grounds is identical, and therefore this court held that interpretation of Article 22(5) and made by the Constitution Bench in Hari Kisan versus State of Maharashtra shall ipso facto apply to Article 22, Clause 1 of the Constitution of India, insofar as the requirement to communicate the ground of arrest is concerned. We may also note here that in para 21 in Prabir Purkayasta, this court also dealt with the effect of violation of Article 22, Clause 1, by holding that any infringement of this fundamental right would vitiate the process of arrest and remand. Para 21, read those Prabir Purkasta case. Here, para 21, the right to be informed about the grounds of arrest flows from Article 22, Clause 1 of the Constitution of India. And any,
Okay, so it was not informed.
yes, Lordship. So that's why in most remaining alleged accused, they have been enlarged on this same arrest memo because ground was not informed properly. It should be informed by written form.
Where is the order passed in the?
Yes, for
case?
other alleged
Case of
accused.
Other accused?
Yes, it's annexed there in page number 44 to 47, one accused, and another accused 48 to 52. Page 44. Lordship.
Hmm.
It's for one accused. He has been granted in the month of November only, because my bill, first bill application was pending before the special court. So I moved very lately before this honorable court due to delay.
So, yes, Mr. Gordo. No ground was communicated.
Yes, my lord. Yes,
Ground was not communicated.
that is a case, my lord. My lord, arrest intimation is there, my lord. But as per my lord, in earlier cases, my lord, in the cases of two accused person, my lord. So same things, my lord, proper ground of arrest was not communicated, my lord. So on that basis, technical ground, both accused person was
Well, when this was arrested?
I was
14-9, my lord, 49. 14-9,
See,
22.
there has been some direction from this court also. And despite of such direction, police are repeatedly doing this. It appears that the police are cooperating with the accused, despite of arrest. In genuine case, or in the case, even in such case also here, this appears to be the very serious case. And police are deliberately, it appears, doing this.
My lord. Allegation is not.
Why there, after bail order, rejection or bail order passed by this court, whether the orders are being communicated to the police department,
Yes, my lord. On our part, we communicated, my lord.
then why these are doing, why this police and authority are not taking steps against IO of the case who deliberately failed to record. There is a format. And then knowing that there is, and then under such circumstances, if the grounds are not communicated, that they are entitled on bail, on technical ground, they are doing this, the police. This is clear cooperation or deliberate action of the police only. And an authority, if the authority is also not taking, then the authority is also cooperating, it appears. Authority is not taking any action. Because every time court used to point out, and it is pointing out of such defect or technical defect in presence of the council, land council. Land council probably has a duty to communicate properly. And I'm just only communication that the bail was rejected, bail was granted. The PP or the special PP is also not merely a post office to communicate that. This is unnecessary. The police has a responsibility to protect the society from such act. And then the there is a incriminating material against the accused for his involvement. He was a vice chairman of the organization. He actively participated, extortion notice, extorted. Court has clearly observed that there is a material on the court while rejecting the bail. Now it has come on the ground of technical defect. And the police knew it, it appears.
I have also personally communicated with the patient. With the judgment notice. Before that, IG crime notice.
So the IG crime is involved.
They said they will conduct a seminar. But,
No, they have never taken any action against the person who deliberately avoid despite of receipt of such information from the IG if they have communicated. And if the IG is waiting for the awareness, then I think without issuing any notice, directive, then I think he is doing something which he shouldn't. He need to actually issue notice or issue order or issue directives to the concerned district. In all the district, it was direction. The direction was to issue all the SP, and then SP in turn will also give a direction to all the police station.
they said they will virtually conduct seminar for.
That is not going to help. That is not going to, unless such police officer who knowingly cooperate with the accused is taken action. You need to take a call. This is useless for the court. Just showing the people it was arrest, but court has granted bail. What is this?
My lord, in my case, my lord, I was appointed as special victim in the month of June last year, my lord. So
After June only the order was passed.
my lord, after that, my lord, this kind of my lord, ground the matter which is pertaining to SIT, my lord, where the ground of proper ground of arrest was not communication. This was the first incident, my lord, I have control, my lord. In my case, my lord.
There was an order passed by this court, whereby while granting bail to the accused and some direction. So we need to reiterate that. Find out that We need to reiterate and refer, and then referring to that first order, second order was also passed, probably. And subsequently, other court also, the coordinate bench,
Right.
probably, is also referred and then passed such order. So we'll pass order accordingly.
Yes.
Okay, hard, Mr. T. Keeper. See, it's difficult when the court has recorded such a serious allegation against the accused, and then to the extent that is threatening or danger to the sovereignty of the state,
My lord.
the country, sovereignty of the India. What more serious case you want?
Yes, no, my lord, it seems the onus lies on the department to conduct seminar on this regard.
Not the
Since
seminar.
learned people is also-
Direction has to go.
Yes, learned people is also already conveyed to the concerned department, my lord.
This is department who is cooperating, none else. Because court, after seeing the records, any court will not be happy to pass such order, only because of the technical ground. And that is also despite of repeatedly directing. Okay, heard Mr. T. Keeper, Learned Counsel for the petitioner. Also heard Mr. L. Kodo, Learned Special Public Prosecutor, SIT, staff. Tara. This application under section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023 has been filed seeking release of the accused Biri Ruja on bail, who has been arrested in connection with New Delhi PS case number 77 stroke 2025 under section 308 to 61 BNS 2023 read with section 13 of UAP Act. What is this? SIT, what is the case number?
SIT case number.
PHQ CBP.
Yes.
What is this? Is this the case number or the earlier one?
Lordship, first case was registered before the New Delhi PS. Case, New Delhi PS SS 77 of 2000.
Okay.
Later on, it was referred to, endorsed to SIT. So SIT has renumbered accordingly.
Okay, renumbered as SIT case number PHQ stroke CB dash PS stroke NRJ New Delhi stroke FIR 77 2025. Okay. No, then it should have been SIT case number arising out of PS case only. We'll record that well, huh? Seeking bail. Who has been arrested in connection with her. SIT case number, that will come first, huh? SIT case number, PHQ CVPS Nirjuli FIR 77/2025 arising out of Nirjuli PS case number 77/2025 under section 308. Same, it will repeat, huh? 2 of the BNS 2023. 61 BNS. Why you are repeating? Under section 308. 2. 61 BNS 2023, read with section 13 of UAP Act. Okay, stop, huh? Para. The land counsel for the petitioner submits that earlier. The bail application filed before the which case rejected on filed before the
07/01/2026.
session judge, filed before the session court. Was a bail filed before the session court for release of the accused was rejected on 7/1/2026. On the ground that there is a serious allegation against the accused and there is a material on record showing that the accused is the vice chairman of United Tani Army who is collecting arms and ammunition to wage war against a nation. The court also observed that the activities of the accused shows that he is a threat to the sovereignty of India. And he demanded no, that's fine. Huh? No. Accused person, he is a trained cadre of United Tani Army and taken training of using arms and ammunition, even shown to have had a contact with chairman of United Tani Army, namely Anthony Doke. Stop, huh? However, at the outset, the Atlantic Counsel for the petitioner submits that by filing this present petition is not seeking bail on merit of the case. However, he seeks bail on the ground of non-compliance with the requirement under section 47
Yes, Lordship. 7.
stroke 48 of the BNSS. And stated, and submits that the accused and the family and his family were not informed. Where have you stated that's not informed? Which paragraph of his, of the ground of arrest at the time of his arrest? Where have you stated?
It's in page number 12, ground of bill, where means I stated that the non-compliance of this part.
And
Roman three.
accordingly, he is entitled to be released on bail for non-compliance of the statutory requirement under section 47 stroke 48 of BNSS. Is laid down in the case of down by the Honorable Supreme Court in the case of Vihan Kumar versus State of Haryana, reported in 2025 SCC online SC 269, and Praveer Purkayastha versus State of NCT of Delhi, reported in 2024 8 SCC 254. Where is the notice? Notice was
Lordship,
given to you.
no notice also. That's
No
why.
notice.
Yes. That's the reason Satyendra Kumar Anfil was also cited in my pleading.
The land council for the petitioner submitted on a similar ground for non-compliance of the statutory requirement under section 47, 48 of the BNSS, the co-accused, namely, who are they?
One is Hansa Pansa. It's in page 44, and one is in page
What is the name of the accused?
Hansa Pansa.
Sri Hansa Pansa, and the other one is
Marlingo.
Malingo, has already been enlarged on bail. For non-compliance. And as police failed to inform the ground of arrest to the accused at the time of their arrest. The counsel for the petitioner made a similar prayer. for release of the present accused. As the police failed to comply with the statutory requirement under section 47, 48 of the BNSS. Stop, para. Mr. El Cordolan, Special PP, SIT, submits that the investigation of the case reveals significant material against the accused person for commission of the alleged offense. However, with regards to the contention of the petitioners, contention made by the petitioner that the accused was not informed the ground of his arrest at the time of his arrest, he fairly submits that upon perusal of the record, relevant record, he did not find and he found that the arrest memo of the accused. Where is the arrest memo? Sir?
In page number 34. Type copy is 35. Page 34 of my petition.
Where the reason for his arrest has been ticked, TICKED, with the appropriate option in the format. However, the ground of his arrest has not been furnished to the accused and or nor to any of his family at the time of his arrest. Charge is already filed.
Yes, ma'am. Charge.
Okay. Then in that case, now the Lana PP further submits that the case has already been submitted into charge sheet. Trial begun?
Not yet, madam.
Not yet.
Not yet.
However, the trial of the case is yet to begin. Stop, huh? Where had the submission advanced by both the Atlantic Council for the parties. I've also perused the record. Stop, huh? on going through the record, it appears that though the region for arrest, the region of the arrest of the accused has been shown in the arrest memo. However, the ground of arrest were not adequately provided or communicated to the accused as well as to his family members. Their wife or family members were never communicated.
No, my lord, as for the records, my lord, it's also in the TCR, my lord. Only this one arrest memo is there.
Only arrest memo.
Yes, ma'am.
Okay, no problem. It's not your fault.
Yes, ma'am.
It's the fault of the person who arrested, knowing that the law has changed. But then this is the statutory Supreme Court order. Otherwise, Sarah, since no, sorry, on perusal of the records, it appears that no notice under section 48 of BNS could be found. There is also no any record showing that the wife or any other family members of the accused was intimated or communicated regarding the arrest of the accused at the time of his arrest. Stop. Huh? Under the circumstances, this court is of the prima facie view that the mandate of section 47 and 48 of BNSS have not been complied with by the arresting authorities while arresting the accused person. Stop. Further, further, while taking into the ratio laid down by the Honorable Apex Court in the case of Vihan Kumar Supra, Praveer Purkastia Supra, this court is of the considered view that at the time of arrest, the accused applicant time of the arrest of the accused person. The mandate of the settled law have not been complied with. And therefore, this court is of the view that the accused is entitled to be released on bail with certain bail for non-compliance of the statutory requirement with certain conditions for ends of justice. Stop. Para. In view of the above, this application is allowed. Stop. The accused, what is his name?
Biri Ruza.
He is directed to be released on bail on furnishing a bail bond of ₹1 lakh with a surety of like amounts to the satisfaction of the which court?
It's a
The
production,
Granite
it's
Session
like,
Court.
Magistrate trial.
JMFC, my lord. JMFC.
JMFC. It's
Yeah.
tribal by JMFC.
Yes,
JMFC, my lord. 7 years punishment is up to 7
Okay.
years, my lord.
Lordship,
Satisfaction of the line judicial magistrate first class UPA
bail bond,
with the
bail bond may be reduced because for remaining it's a 50,000 lordship only.
he's a main accused.
No,
He's a boss.
lordship,
boss,
he's
yes.
not main accused lordship. He has been asked just to check the name only, that's only. Otherwise, he's not main.
He's a vice chairman.
As-
Only one person is above him.
As for the police,
On the subject to the following conditions. Stop. That the accused shall investigation complete.
Yes, charge is in, my lord. Already charged.
Okay. Shall appear each and every date of trial before the court. Each and every date. Okay. Appear before the court for trial on each and every date as may be fixed by the trial court. Stop. That accused shall not hamper or tamper with the evidence. That he shall not try to influence or threat anyone in connection with the case in any manner. In the event of the violation of any of the above conditions, the bail shall be liable to be cancelled. Okay, stop with the above. This petition is stands disposed of. Okay.
Obliged.
highly obliged lordship.
Item number 13, so unlisted motion matter.
13, Mr. Key, I'm not inclined to take up the matter
Right.
because it will take me time.
Otherwise, I'll
This
take
for
only,
correction of
I'll
this
take only 3 minutes.
3 minutes, but then for again,
Only to prime facie show that I'm nowhere involved in this case.
I have a case. Then I have see these 5 cases. I'm yet to correct.
Till
it.
then, my lord, only till Monday, then I may be protected. my
Those
lord.
are the half dictated. It will take me time.
Only till Monday I may be protected. I have to appear as a central superintendent tomorrow, my lord. Till Monday I may be protected. There's nothing on record, my lord, prime officer. Till Monday. If there's something against me, my lord, I will
See.
withdraw my case on Monday. My statement has been recorded twice, my lord.
See, the case of child, sensitive, we need to see the record.
But my lord
We need
may
to see the
produce the FIR also, my lord. It's a case of,
Otherwise, it involves with the society blames, because the entire school.
Right.
School, for each and every students, there is, parents.
Right.
And relatives. It involves with the whole thing. It's very difficult.
they say
And
that
the incident occurred in the school,
24th.
and unless we see the record, it will be difficult to
but-
protect.
The prima facie FIR itself discloses the fact that there is no case of abetment at all, my lord. I can justify, demonstrate it from the FIR itself, my lord.
No,
my
I
LSC.
am really not inclined. I don't-
Till Monday, if my lord.
No,
will be
no,
allowed to-
protection would be a little difficult.
Yes, Lordship, there is a suicide note also, Lordship, in the
But suicide note does not implicate me, my lord. In no manner,
Not necessary at the moment.
my lord.
The investigation will.
The
find it
abetment of
out.
suicide has to be justified from the suicide note
So
itself. my
where
lord.
is the FIR?
FIR, my lord, may kindly have page number. Yes. 24, my lord.
Hmm?
24. And type copy is at my lord, page number 28, my lord. If I may read, man.
Hmm.
FIR regarding suicide of minor student Miss So-and-so, daughter of So-and-so of Government Girls Residential School, Mitpu, Doimu. Respected sir, that my sister Miss So-and-so was a class 8 student of Government Girls Residential School, Mitpu,
See,
Doimu.
a little difficult. Hmm.
Otherwise, prima facie, my lord, there's no case of abetment at all. If my lord peruse the FIR for a once, my lord,
Or
I'll
if I
convince my lord.
have to come back up to, it will be difficult.
My lord.
Monday.
Monday, no.
Lordship, till then, Lordship,
No. I need to peruse, I need to hear him as well.
Lordship,
So it will be difficult. Monday.
since Lordship, I have given my statement as my brother also has said, we have given our statement before the invest twice, not once, twice, Lordship. And Lordship, since I'm a woman, Lordship, that's what I'm,
Have you annexed those statement?
that is like, that cannot be
Maybe
provided.
statement needs
Lordship,
to-
we have categorically stated in our abutment, we have,
Do you have the copy of the statement?
No, Lordship.
No.
that is not, that cannot be
Need to
given.
see, at least that statement need to see.
Lordship, that's what I'm saying. We have made a categorically abetment in our petition, Lordship. If that is not there, Lordship, our, there's always this honorable court can cancel our interim granted, Your Honor.
No, that is there,
That-
there naturally, but
That's
then,
why Lordship, I'm saying, if Lordship
no,
wants to
no.
peruse the matter, Lordship, let grant us a interim till Monday, Lordship. If there's anything against us, Lordship, there's always a,
Only for 2 days, my lord.
only for,
That subject to the outcome of the case, Daddy, man. We'll justify that there's nothing against us, man.
and since Lordship, we have stated, we have given twice, not once, twice,
What,
Lordship.
have you annexed suicide note also?
Oh.
We could not get hold of it, my lord. That's a part of the investigation.
Okay, you have an instruction.
Need instruction, Lordship.
And Lordship,
This-
in the FIR,
Whether-
also,
This is
whether
the
in the-
this is for the first time, Lordship. This is unlisted, Lordship. So we don't have any Lordship record, Lordship.
Lordship from the FIR also,
Suicide note, whether the name is any person's
no,
name given,
Lordship, we have.
no idea.
No one.
Do you have any idea?
No, Lordship.
On the basis of the suicide note, this FIR was registered by this, our elder brother. And there's no whisper of anyone here. It's just a general FIR.
No, you are there in the school age in what capacity?
My lord,
And you?
And Lordship, no, I'm as a teacher, Lordship, and I'm like, I don't stay, I don't stay in the hostel, I stay here in A sector, Naharlagan.
How
And
many
Lordship,
persons-
she is
how many
chairman of
persons- How many
ex-committee.
persons were called for? Or
All the Lordship, if I've been in for all the teachers, staff have been called by the investigation officer.
okay.
Lordship, here in FIR,
So
also,
the
it says,
person stay in hostel?
I don't stay in the hostel, Lordship. I come
No,
here
no, no,
from the.
the person who died, the.
Yes, Lordship,
child.
it's a girl hostel, Lordship. There are 112 students in that hostel. And
And
out of that, Lordship,
You are not connected with the hostel
I'm not connected with hostel.
neither I am connected.
That's,
administration?
that's why, Lordship, I'm saying.
And probably if you have already given statement, probably you would not be required.
Yes,
At the
Lordship.
moment-
Exactly, Lordship.
We have been asked to come again.
No, because if you are innocent, if anticipatory bail is granted to you, the other will take advantage of it.
No, Lordship, who are
Excuse-
before this honorable
No,
court.
the Monday.
Lordship, that's what I'm saying,
Sorry.
Lordship. May I, Lordship, the incident took place on 21st and the untoward incident happened on 24. Lordship,
Let
kindly.
let us see at two. Okay.
Till then, Lordship, PP kindly
So we'll fix it on Monday.
Yes,
You put this, but Mr. So key, and counsel for the petitioner. By filing this application under section 482 of BNS S 2023, the petitioner seek pre-arrest bail, apprehending arrest in connection with the PS case number 21/2026, registered under section 108, 127 to 79(3)(5) of the BNS 2023, read with section 75 of Juvenile Justice Care and Protection of Children Act 2015. Staff, Mr. Loy Lanet PP, some state. There is also suicide not left by the deceased. Therefore, he needs to obtain instruction in this regard. Staff. They are allowed to list this matter on Monday, on which date Mr. Loy shall produce the case diary.
Scanned copy of this.
Complete.
Scanned copy of the case diary. Okay.
My lord, a small prayer, my lord.
Yes.
If my lord agrees, my lord. On 28/2/2026, that is tomorrow. So she has to attend as a central superintendent, my lord. So only that may be allowed tomorrow for the exam of class 5 and class 8, my lord. Kindly have page number 30, my lord.
This in this 16, huh? This is 16 is yours.
Yes.
Jerick Basar.
Yes, my lord. No, 15. 16, my lord. Kindly have page number 30, my lord.
Page 30.
30, my lord.
Yes, Mr.
On 28/2/2026,
At
previous
this stage,
exam of
Mr.
class 5.
Key, huh? Direct counsel for the petitioner submitted the applicant. What do we say?
Center superintendent, madam. Center superintendent,
She is central superintendent.
she has been appointed as a center
said that-
superintendent.
The applicant has been appointed as central superintendent. Where do I find the post?
My lord, page number 31. Serial number 13, my lord. From above, if I may read, my lord. Following headmaster, head teachers, and teachers are appointed as center
Okay, the petitioner has been appointed as
center superintendent
central superintendent.
to conduct Arunachal Pradesh State Board Examination 2025.
Superintendent to conduct
Conduct
Arunachal Pradesh State Board Examination 2025
26
in respect of class 5
and class 8.
25 and 6 in respect of class 5 and 8.
Which is scheduled on 28/2/2026
Scheduled on 28
to 2026.
to 2026.
No course of action till then.
Therefore, C may be protected on 28.
28, pardon, 28/2/2026.
C may be protected from any coercive action against her on 28
to
to
2026.
2026. Staff. Okay, it is in this regard, it is provided that till 2028, no coercive action shall be initiated against the applicant in order to enable her to attain the duty as central superintendent for conducting the state AP State Board Examination 2025-26. Staff. Till 28, huh? Not this week.
on Monday, madam.
May it please your lordship. May it please your lordship.
But you are not attending the 28?
Lordship, since I'm a teacher in that school, similar in our school also the examination will be conducted, so I'll be supervising and since the learned,
Oh, your name is there?
Lordship, this is for other, she has been given. in
Okay,
other
okay.
school.
Some is that, this exam is going to conduct in your,
Yes, in my.
Okay.
school also,
then in that case, the examination for so and so is going to be conducted in their school, where she also has been assigned duty as invigilator or invigilator. So, in the invigilator, huh? So in view of the above and in this regard, same, okay. Up to 28 only.
Yes.
Okay.
Last item also same. Correct, but same.
How many items?
Three items.
Okay,
Also-
same with the
Teacher.
item.
Yes, man, same.
Item-
Okay. Same.
Grateful, man, grateful.
Okay.
Lordship, I am appearing in item number 1. And the VC was not, so your lordship, that was at that time the VC was not working. So I could not attend. Later on, I have joined your lordship now. Your lordship may take it up the matter today.
Which one? Item one.
Item 1, your lordship.
Item one.
Dispose lawsuit.
Dispose of with a direction to approach,
Lordship.
with a liberty to approach before the trial court, because it is a compoundable case. Liberty is granted.
Your lordship, what has happened? No, yes, I'm understood, but only thing, your lordship, he is ready to pay the whole amount. Since he is ready to pay the amount, your lordship, at least that protection may be given, then he will
Not a
pay the
question of-
amount, your
not a
lordship. He
question of-
only out of
What is
that.
this? What is this? What is this?
He has
Criminal
taken
petition
an
only.
amount. Yes, yes. He has
It's
taken an
compound-
amount of
Learned counsel, it is only
6.5 lakhs.
compoundable. It is only compoundable. It will be compounded only. You just approach the trial court. Why you're approaching the high court?
Yes, Lord.
Okay. Yes.
So this is because